In just 38 days, the landscape of gun ownership and concealed carry in America is going to shift in ways most people are completely unprepared for. 5 major legal changes, some federal, some state level, and one that could alter the meaning of concealed carry nationwide, are already scheduled, already signed, and already on the books. And while most gun owners are going about their daily routine unaware of what's coming, the clock is ticking. When January 1st arrives, these laws won't be proposals or rumors floating around online. They will be real, enforceable, and powerful enough to turn a law-abiding gun owner into a felon literally overnight. Before we dive in, it's important to understand that what you're about to hear is not speculation. These are confirmed changes with implementation dates already locked in. Some of them even took effect quietly in late 2025, without headlines, without news coverage, and without the attention they deserve. If you carry concealed, if you own an NFA item, if you live in or travel through states like Colorado or Kentucky, or if you've ever filled out a Form 4473 at a gun store, then at least one of these changes will affect you directly. By the end of this video, you'll know what's changing, why it matters, and what you must do to avoid catastrophic legal consequences. So let's start where the countdown begins. January 1st, 2026. On that day, a change decades in the making will finally take effect. For the first time since 1934, the $200 NFA tax stamp fee is being eliminated. At least that's the headline most people have heard, usually followed by cheering, celebration memes, and people promising they'll finally buy that suppressor they've been eyeing. But as with all things involving the federal government, the truth is more complicated. Yes, it's true. Starting January 1st, you will no longer have to pay the $200 tax to register suppressors, short-barreled rifles, short-barreled shotguns, or any item classified as any other weapon under the National Firearms Act. That fee has been part of federal law for 91 years, originally designed to make owning these items practically impossible. And while the fee is disappearing, the registration requirement is absolutely not. The ATF still demands fingerprints, photographs, background checks, and approval, whether you pay the fee or not. That's the part most people overlook. There's a catch, too, a big one. If you already submitted a Form 4 and you already paid the $200 ahead of the deadline, you're stuck. The ATF will not refund your money. It doesn't matter if you mailed it yesterday or last month. That fee is gone forever. So if you're planning to buy or register an NFA item, you'd better wait until the clock strikes midnight on January 1st. Submitting early could cost you hundreds of dollars for absolutely no reason. But the elimination of the fee opens a different door, one most people haven't even considered yet. When the financial barrier disappears, demand will skyrocket. Everyone who avoided suppressors or SBRs because they didn't want to waste extra cash will now join the line. Dealers know it, manufacturers know it, and the ATF knows it. Approval times will likely stretch even longer. On top of that, some states, California, New Jersey, New York, Illinois, Massachusetts, Rhode Island, Delaware, and Hawaii still completely ban suppressors regardless of federal registration. So while the federal government removes one obstacle, state governments are tightening their grip. What should concern you even more is the penalty for failing to register. If you possess an NFA item that isn't registered, even after the tax stamp disappears, you're still committing a federal felony that carries up to 10 years in prison and a $250,000 fine. The ATF doesn't care that the fee is gone. They care about the database. The law is still the law, and it will be enforced. While the federal government removes one barrier, it's simultaneously building new ones in a far more dangerous area, Federal sentencing guidelines. On November 1st, 2025, completely under the radar, the United States Sentencing Commission implemented new guidelines for firearms-related offenses. These changes doubled penalties for straw purchases, false statements on Form 4473, and illegal transfers. What used to be a 5-year maximum for buying a gun on behalf of someone who couldn't legally own one is now a 10-year maximum. What used to be a 2-year maximum for lying about drug use on a Form 4473 is now a 5-year maximum. But the penalties themselves aren't the scariest part. What's far more alarming is the new way the ATF is enforcing these violations. They are now cross-referencing gun purchase records with social media posts, medical marijuana registry data, DUI arrests, drug possession charges, and even store security footage. If you post a picture smoking marijuana but check no on the question asking whether you are an unlawful user of controlled substances, that post is evidence. If your buddy with a felony conviction sends you money electronically the same day you buy a gun, that transaction is evidence. If a family member says you purchased a gun for someone else, whether it's true or not, that claim is evidence. Federal prosecutors now have sharper tools, higher penalties, and the political motivation to push these cases aggressively. They prosecuted more than 300 straw purchase cases in 2024. That number is expected to double, maybe even triple, in 2026. A false statement on a background check form, something many people dismiss as a minor issue, can now destroy your life. And while federal enforcement becomes stricter, states are building new frameworks that reshape the purchase and ownership process entirely. Colorado is the next example, and its change will be felt across the nation beginning August 1st, 2026. Colorado passed Senate Bill 3, requiring anyone purchasing a semi-automatic firearm to complete a state-approved safety training course before taking possession. This isn't a simple online quiz or a casual safety briefing. The course must be at least 4 hours long, cover safe handling, storage, state-specific gun laws, and include a live fire qualification. Only state-approved instructors will be allowed to teach it, and their certification list won't be published until June of 2026. This law essentially transforms firearm purchases into a licensing system similar to obtaining a driver's permit. And while existing owners are grandfathered in, anyone who wants to buy a semi-automatic pistol, rifle, or shotgun after August 1st must comply. With Colorado leading the way, you can expect other states, especially Washington, Oregon, New Mexico, and Michigan, to explore similar laws. And if you think gun stores will look the other way, think again. Dealers who transfer a firearm without verifying a buyer's training permit face the same criminal charges as the buyer, a Class 2 misdemeanor, up to 120 days in jail and fines. Colorado's law is only one piece of the puzzle, though. Kentucky is heading in the opposite direction, but in a way that may be even more intrusive. On February 1st, 2026, Kentucky will begin enforcing its new Extreme Risk Protection Order system, known commonly as a red flag law. Kentucky is the 22nd state to adopt such a law, but its version is one of the most expansive in the country. The list of people who can file an ARPO against you includes current or former spouses, anyone you've lived with in the past year, anyone you've dated in the past year, any family member by blood or marriage, and any law enforcement officer. And the standard required for an emergency order is shockingly low. Reasonable cause to believe that you pose a danger to yourself or others. That's all it takes for a judge to immediately suspend your concealed carry permit and require you to surrender your firearms within 24 hours, even before you get a hearing. You won't receive a warning. you won't receive a request for explanation. In many cases, the first sign will be a knock at the door from law enforcement informing you that you must immediately surrender every firearm you own. Only 14 days later will you have the opportunity to defend yourself in a hearing. If the judge decides against you, a permanent order can last up to 1 year and can be renewed again and again. Violating an ERPO, in other words, simply possessing a firearm while the order is active, is a Class D felony in Kentucky. That means 1 to 5 years in prison. And even after the order expires, you don't automatically get your firearms back. You have to petition the court for their return, and the court can refuse. All of these changes are significant in different ways, but there is one more potential shift that overshadows them all: a federal bill that, if passed, would rewrite concealed carry rights across all 50 states. This is the Constitutional Concealed Carry Reciprocity Act, also known as House Resolution 38, reintroduced in 2025 with more than 200 co-sponsors. If passed, your concealed carry permit would work nationwide, just like your driver's license. California, New York, New Jersey, Illinois. They would all be required to honor permits issued in Texas, Arizona, Florida, or anywhere else. Imagine driving coast to coast, legally armed the entire way, without navigating a confusing patchwork of reciprocity maps and state-specific restrictions. For millions of concealed carriers, this would be the most liberating change in American gun law in generations. But the bill is not law yet. It hasn't passed the House. It hasn't reached the Senate. And even if it does, it will face legal challenges from states that refuse to recognize out-of-state permits. Until this bill becomes law and survives the inevitable lawsuits, you must follow current reciprocity rules. One wrong assumption could lead to a felony charge if you carry in the wrong state. So where does all of this leave you? 5 major changes, 3 fixed deadlines, 1 massive potential federal overhaul, and millions of gun owners who could fall into legal jeopardy simply by being unaware. Your action plan begins with marking your calendar. January 1st for the NFA change, February 1st for Kentucky's ERPO system, August 1st for Colorado's training requirement. Understand that sentencing guideline changes are already active as of November 1st. If you intend to buy an NFA item, wait until after January 1st to avoid losing $200 for nothing. Never buy a gun for someone else unless they are legally eligible and the transfer follows the law. Do not lie on Form 4473. And always verify reciprocity before traveling across state lines. The world of gun ownership is changing faster than ever, and staying legal today requires staying informed tomorrow. These new laws are only the beginning, and more changes are already being drafted in state legislatures and federal committees. If you want to stay ahead of what's coming next and avoid becoming an unwitting test case for new regulations, make sure you stay alert, stay updated, and stay prepared. Gun ownership has always come with responsibility. Now it requires vigilance. The laws are evolving. The enforcement methods are evolving, and the consequences for falling behind are more severe than ever. Stay safe, stay legal, and keep watching, because this story is far from over.